Welcome to EPG Pathshala. This is Professor Arvind Tiwari, Professor of Criminology, School of Law, Rights and Constitutional Governance, Tata Institute of Social Sciences, Mumbai. We will discuss about the human rights, meaning, definition and scope. The structure of the module would be, first, the introduction, in which the concept of human rights, what are the human rights, definition of human rights, universality of human rights, and human rights debate and approaches would be discussed. Also, why human rights are important, historical background, normative structure of human rights, international and domestic law, and in the end, summary of the module. The value system manifested in the idea of human rights is not necessarily modern or an imported concept from West. It is not something alien to our culture, but found in all major cultures and religions in India and abroad. Human life, dignity, freedom, equality, and property were posted by moral commandments. From the Vedic literature, we have evidence highlighting the duties of the king and rights of the citizens. The duties were focused to achieve welfare, equality, and justice by maintaining human dignity. In this vast geography called India, there is no language, culture, religion, or practice which allows humans to deal with another human inhumanly. Any such practice, if practiced, does not have a sanction of the culture or religion and is practiced based on the misinterpretation of the norms and practice. Concept of human rights. According to Mr. Justice M. Ramajoyce, Bharatiya values regarding human rights perhaps have the oldest pedigree. The Rig Veda, which is regarded as the oldest document, declares that all human beings are equal and they are all brothers. According to the Atharvaveda, all human beings have equal right over food and water, including natural resources. The Vedas, including Upanishad, Shruti, were the primordial source of dharma, a compendious term for all human rights and duties, the observance of which was regarded as essential for securing peace and happiness to individual as well as society. The Smritis and the Purans were collections of the rules of dharma, including civil rights and criminal liabilities. Vyavhar dharma, as also Raj dharma, constitutional law, which were developed on the basis of fundamental ideals incorporated in the Vedas. There were also several other authoritative works on Raj dharma. The most important of them were the Karma Kanda, Sukraniti, and Kautilya Arthashastra. All of them were intended for securing happiness to all. Now, what are the human rights? The concept of human rights has two basic meanings. The first refers to the inherent and inalienable rights due to man, woman, simply by virtue of his or her existence as a human being. These are moral rights and they aim at ensuring his or her dignity as a human being. The second sense is that of legal rights, which are established through the law-creating processes of societies, both national and international. It is generally believed that the state is the guarantor and protector of human rights. Human rights, as the term is most commonly used, are the rights which every human being is entitled to enjoy and to have protected. The underlying idea of such rights, fundamental principle that should be respected in the treatment of all men, women, children, exist in some form in all cultures and societies. Human rights are not gift or bounty of any political superior. The laws are meant to reaffirm and recognize human rights and to provide mechanisms for their enforcement. The upholding of rights is essential for maintaining human dignity. All human rights for all is the goal of the century, and the aim is to ensure that human rights are universally accepted and respected. The 7 essential freedoms are: 1. Freedom from discrimination by gender, race, ethnicity, national origin or religion. Next, freedom from want to enjoy a decent standard of living. Freedom to develop and realize one's human potential. Freedom from fear of threat to personal security, from torture, arbitrary arrest and other violent acts. Freedom from injustice and violation of the rule of law. Freedom of thought and speech and to participate in decision making and form associations. And freedom from decent work without exploitation. Now, human rights are indivisible, interdependent and interrelated, having a clear linkage with human development, and both share a common vision with a common purpose. The emphasis is on human dignity is laid in the Charter of the United Nations, Universal Declaration of Human Rights, which is also called UDHR, and several international covenants. Same is the emphasis in the Constitution of India, which assures dignity of the individual as a core value in the preamble. The Constitution of India was drafted nearly at the same time as the UDHR and contains similar provisions. Part 3 of the Constitution, containing the fundamental rights correspondent to Article 21 of the UDHR, and the directive principles of state policy in Part 4 of the Constitution correspond to Article 22 to 28 of the UDHR. The International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights, both of 1966, are a further elaboration of these rights. Now, I will come to the definition of human rights. According to Section 2D of the Protection of Human Rights Act 1993, human rights are defined as under. Human right means the rights relating to life, liberty, equality and dignity of individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. Now, universality of human rights. Vienna Declaration 1993 reaffirmed the universality of human rights. The universal nature of these rights is beyond question, says the final declaration. The entire spectrum of human rights was endorsed without division. All human rights are universal, indivisible, and interdependent and interrelated. The declaration says human rights were reaffirmed as including both civil and political rights and the broader range of economic, social and cultural rights, as well as the right to development. This full conception recognizes in the word of the final declaration that the human person is the center subject of development. Now, why are human rights so important? Human rights are important because they recognize that each person is special with his or her own individual talents and abilities, and that no one is inferior or superior to another. At the heart of the idea of human rights is the notion that all people are born free and equal. Everyone is entitled to live with dignity, and no one, including the state, community, family, and society, has any right to discriminate or treat anyone unfairly or unjustly. The International System of Human Rights and Indian Constitution insists that it is the duty of the state to promote respect for all the humans, rights of all people equally. Now, briefly I'll discuss about the historical background. The English experience first. Historical background. The English experience. The origins of the contemporary conception of human rights can be traced from the period of Renaissance and later on enlightenment of humanism may be said to be heart and soul. The English American and French revolutions in their own ways contributed towards the development of democracy in which certain rights were regarded paramount in protecting individuals from the state. The Magna Carta of 1215 was associated with the liberation of man, while the Bill of Rights of 1689 was directed towards the protection of individual rights. The Glorious Revolution of 1688 provided a precedent that rulers could be removed by popular will if they failed to observe the requirements of constitutional legitimacy. Now, I will discuss the American experience. The rights of man found clear in felicitous expression in the American Declaration of Independence, 1776, which was drafted by Thomas Jefferson. We hold these truths to be self-evident that all men are created equal and they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, desiring their just power and consent of the governed, that whatever any form of government becomes destructive, these ends, it is the right of the people to alert the abolition. The Bill of Rights of 1791, adopted by the United States, contained the list of guaranteed individual rights. The French experience. Although the French Revolution and the American struggle for independence had many common features, they differed in one crucial aspect. Whereas the rebellious colonies had simply sought to establish themselves as an independent sovereign nation, the French revolutionaries were concerned with the demolition of an old absolutist system of government and the establishment of a new democratic order. This, of course, posed the same question of legitimacy which had been raised by the English Revolution a century earlier, where the English had rid themselves from their monarch by enforced abdication. The theoretical solution to this problem identified the French taking the lead from American nations of popular legitimacy was that of self-determination. The central proposition of this concept was that the sovereignty of a nation lay with its people, and any government which was not responsive to its citizens' demands could be changed by expression of the popular will. The French Declaration of the Rights of Man and Citizen, 1789, pronounced, "True happiness is to be found in individual liberty, which is the product of the natural, inalienable, and sacred rights of man." Thus, while the declaration it states that certain individual rights are protected, the rights to due process, the presumption of innocence, the freedom to hold opinions and religious belief, and the freedom to communicate ideas and opinions, it prefaces these with a clear liberation philosophy. Article 2 of the Declaration provides that the aim of every political association is the preservation of the natural and imprescriptible rights of man. These rights are liberty, property, safety, and resistance to oppression. The history of advancement of human society over the 19th century reveals that the rights are by nature inherent, universal, and inalienable. The protection of rights is best afforded within a democratic framework, and the limits of the exercise of rights could be determined by abrogating only by law. Bolshevik Revolution in Russia, 1917. Since the 19th century, the Tsar of Russia was ruling with ruthless authority. In 1917, a general strike was called and the army refused to fire on the strikers. In this way, full revolt broke out. Tsar Nicholas was abdicated and Russia came under the rule of Bolshevik. Lenin emerged as a strong man of Russia and he resorted the fundamental rights of the citizens, particularly the rights of working classes and the proletariat. Industrial Revolution 1930. As a result of industrial progress, England was turned into a manufacturing country. However, the conditions of workers employed in the factories were very deplorable. Their basic rights were being ignored, and in 1930, the government enacted industrial laws and ensured human rights to work to secure proper wages and suitable working conditions. Now I will come to the normative structure of human rights, international and domestic laws. India had representatives in the drafting committee of the UDHR and is bound by the provisions of the two international covenants, that is, International Covenant on Civil and Political Rights (ICCPR) and International Covenant on Economic, Social and Cultural Rights (ICESCR). The Constitution of India guarantees almost the entire gamut of civil rights and political rights through Chapter 4 of the Indian Constitution that deals with the directive principles of state policy. The government is mandated to promote a variety of social and economic rights that would lead to an equitable social order and betterment of the quality of life for all sections of society. The rights of or obligations which flow from the international covenants to which India is a signatory can have meaning and substance only if they are included in the Constitution or other domestic laws. In this context, the format of Indian Constitution in respect of human rights is remarkable, as it has sought to achieve a delicate balance between what has been termed as civil and political rights on the one hand and social, economic and cultural rights on the other. The Constitution makers believed in giving equal importance to the two sets of rights as a cardinal tenet of the philosophy underlying it. While the civil and political rights are made fundamental and judicially enforceable, even though subject to reasonable restrictions, the economic and social rights are also made basic to the governance of the country and to have to be progressively realized through administrative action and legislative acts. Charter of the United Nations. Enforceable human rights in the Constitution and the law. I will talk about this. It is said that a constitution is basically a people's covenant, their charter of freedom and the blueprint for their future. As it is, the Indian Constitution is envisaged to be an instrument for economic growth and social change. The achievement of social and economic democracy, as much as political democracy, has been one of the cardinal concerns of the Indian Constitution. The fundamental rights and directive principles of state policy are key elements of the overriding concern. Dr. B.R. Ambedkar, in his concluding address, stated as follows in the Constituent Assembly, I quote, "Political democracy cannot last unless there lies at the base of its social democracy." What does social democracy mean? It means a way of the life which recognizes liberty, equality and fraternity as principles of life. These principles of liberty, equality and fraternity are not to be treated as separate items in the Trinity. They form a union of Trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be divorced from equality, equity cannot be divorced from liberty, nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the same supremacy of the few over the many. Equality without liberty would kill individual initiative. Without fraternity, liberty and equality could not become a natural course of things. Now I will discuss about some provisions of the Indian Constitution. Article 14, equality before laws. Article 17, abolition of untouchability. Article 19, fundamental freedoms. Article 21, protection against conviction or enhanced punishment under ex post facto law. Article 20/2, protection against double jeopardy. Article 23, protection against self-incrimination. Article 21, protection of life and personal liberty. Article 22, right against arbitrary or illegal arrest. Article 23, abolition of bonded labor. Article 32 and 226, right to remedies for enforcement of human rights. Article 46, promotion of interest of weaker sections. Article 39A, free legal aid to the poor. Now I will come to the provisions in the Criminal Procedure Code. Section 57, 41/151, 46, 49, right against arbitrary or illegal arrest. Section 50, right to be released on bail. Section 47, 51, 100, right against arbitrary or unreasonable searches and seizures. Section 54, 162, 164 and 176, protection against cruel or inhuman treatment during investigation. Article 53 and 54, detainees should have the right to a medical examination. Section 150, women and children should not be taken to police stations for purposes of investigation. Section 300, protection against double jeopardy. Section 161, protection against self-incrimination. Indian Evidence Act. Now these are the provisions in this act. Section 24, 25 and 26 says protection against cruel or inhuman treatment during investigation. Section 101 to 104, right to benefit of doubt. Section 113A, 113B and 114A, protection of women against certain crimes. Now provisions in the Indian Penal Code. Section 330 and 331, protection against cruel or inhuman treatment during investigation. Section 376 and Section 304B, protection of women against certain crimes. Now Code of Conduct for the police also have the provisions. Clause 1, 3 and 4, protection of human rights. Clause 7, Code of Behavior for police officers. Above all, the Constitution clearly states that the state shall not make any law which takes away or abridges the rights conferred, and that any law made in contravention of the clauses shall to the extent of contravention be void. Now I will discuss briefly about the directive principles of state policy and practice of welfare state model. The directive principles of state policy are essentially in the nature of certain directions to the state while making laws. The Constitution provides that the directive principles are not enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in the making of laws. Essentially, the directive principles enshrine the ideal of social and economic democracy and are humanitarian in social precepts which aim at the realization of a welfare state. In crux, the directive principles are intended to ensure the dignity of human life and pursuit of happiness. In this regard, several legislative measures have been taken both by Parliament and state legislatures to secure these objectives. For example, the right to compulsory primary education, which is referred to in Article 13(2)(a) of the ICESCR J.P. Unnikrishnan versus State of Andhra Pradesh. Second, the right to health, which referred to in the Article 12(1) of the ICESCR State of Punjab versus Mohinder Singh Chawla. the right to shelter, which is referred in Article 2 of the ICESCR, and the right to food, which is again referred in the Article 11.1 of the ICESCR, Madhu Keshwar versus State of Bihar. The right equal pay for equal work, which is referred in Article 7(e)(1) of the ICESCR, Randhir versus Union of India. Right to legal aid, Madhav's State of Maharashtra versus State of Maharashtra. The National Commission to review the working of Constitution, headed by Mr. Justice M.N. Venkat Chalaiya, former Chief Justice of India and Chairperson NHRC, in its report submitted to the Government of India in March 2002, recommended the establishment of a body of high status which first reviews the state of the level of implementation of the directive principles, in particular, number 1, the right to work, the right to health, third, the right to food, clothing and shelter, 4, right to education up to and beyond the 14 years, and 5, the right to culture. The report also enumerated various steps to be taken for ensuring that the directive principles of state policy are realized more efficiently. Now I will explain the fundamental duties. The proliferation of rights and dilution of corresponding duties has been a cause for concern. One response was the 42nd Constitution Amendment, which incorporated certain fundamental duties of citizens in Article 51A of the Constitution, which are conformity to the Constitution, its ideals and institutions, respect for the national flag and the national anthem, cherishing ideals of freedom fighters, protection of sovereignty, unity and integrity of the country, defense of the country and performance of national service when called for, harmony amongst people cutting across religions, linguistic and regional diversities, and upholding the dignity of women, preservation of heritage and composite culture, protection of environment, development of scientific temper, safeguarding public property and abjuring violence, and striving for all-round excellence, individually and collectively. It is debatable whether fundamental duties by themselves are justiciable and can be directly enforced in a court of law. What is urgently needed is the creation of a citizenry conscious of their rights and duties. Measures must be adopted by the union and state governments to promote an awareness of constitutional rights and responsibilities among citizens and to sensitize them to the various values embodied in our Constitution. The Justice Verma Committee on Fundamental Duties of Citizens has rightly observed that, I quote, the desired enforceability can be better achieved by providing not merely for legal sanctions but also combining it with social sanctions and to facilitate the performance of the task through exemplary role models. The real task, therefore, is to devise methods which are a combination of these aspects to ensure a ready acceptance of the program by the general citizenry and the youth in particular. I unquote. Now I will summarize the module. Honorable Supreme Court, in a landmark judgment, Mrs. Santosh Singh versus Union of India and others, has observed, I quote, the purpose of education is to engender in the young a spirit of inquiry, a desire for knowledge and a sense of values. Among those values are the fundamental values on which our constitutional core is founded: liberty, equality, and the dignity of each individual. The purpose of education also includes the creation of responsible and informed citizens conscious both of their rights and of their duties to others, unquote. What is now needed for protection and promotion of human rights is a concerted effort to create a nationwide awareness of the need for systematic reforms to ensure good quality governance. The reforms may include decentralization of power of grassroots levels, planning, and polity building from the base, disciplining our political parties and politicians, streamlining criminal justice administration, aiming to adhere to rule of law, and participation of citizens in day-to-day governance. Criminal justice administration aiming to adhere to rule of law and participation of citizens in day-to-day governance. Last but not least, the important task for protection and promotion of human rights would be educating the people regarding their rights and obligations. Thank you.